that don't understand English, and we have a title case appeal. We have, like Chief Marilyn says, proven declaration of rights, proven title.
We have never ceded nor surrendered our rights or our title as Indigenous peoples on our lands, and the government has not settled that title issue.
The Tsilhqot'in National Government was formed in 1989 to represent local First Nations communities in legal proceedings for rights and titles claims against the government of British Columbia.
Through this long and ongoing struggle for legal power to make decisions and control activity on their traditional territory, Aboriginal rights have been proven over 4,400 square kilometers of territory around the mine's proposed site, shown in light green on the map. However, Aboriginal title has not yet been granted to any part of this area.
In 2007, the BC Supreme Court ruled in favor of Tsilhqot'in by declaring Aboriginal rights throughout the area in question. Although this ruling was a great success, shortly afterwards the Court of Appeals dismissed the right to claim title.
The court insists title must be proved by intensive use of an area over time, not simply showing a limited presence over a broad expanse of terrain.
In 2010, the Tsilhqot'in Nation appealed this decision and is still awaiting ruling. The ongoing struggle for traditional rights and territory makes the new Prosperity Mine proposal highly contentious. The Court of Appeals defines title to only include sites with specific and intensive occupancy. Tsilhqot'in, or Fish Lake, is one such important area that clearly meets this designation.
Currently, the Tsilhqot'in Nation holds the right to trade furs, capture and use wild horses, hunt, trap, and fish, as well as the right to halt any logging within the claim area surrounding the mine site. This claim area, however, is only a fraction of the Tsilhqot'in's traditional territory, and they hold no legal power over the rest.
Tsilhqot'in people are intrinsically connected to the land around Fish Lake, and the current environmental assessment has not adequately addressed its spiritual significance. The environmental assessment process and requirements for the Tsilhqot'in Nation's involvement are very culturally different than their lifestyles and result in much confusion and distrust with the government. The current mine proposal impacts the Tsilhqot'in Nation's rights and title because of the nation's rights to trapping and hunting in the claim area, and because the initial mine proposal was rejected in part because of the many severely negative impacts it would have on the Tsilhqot'in Nation's title claims to the land around Fish Lake.
There should have been only one process, which would have been a joint review panel. And that process had been changed unilaterally without our consultation.
Even more so, the current proposal was already rejected within the first proposal and has now been put forward in a political climate that makes the protection of the environment and of First Nations rights and title even more difficult.
The new Prosperity Mine proposal is still being considered for approval, despite being in an area where Aboriginal land claims and title have not been resolved. In order to better protect Aboriginal rights and title, all land claims should be dealt with before any environmental assessment process is undertaken, and the duty to consult and accommodate during the assessment process must be fulfilled. Any future decision made in the new Prosperity Mine case will affect not only the Tsilhqot'in people, but all Canadians. It strikes into the very heart of Canada's history and threatens to undermine ethical and sustainable issues that can no longer be ignored. The loss of Fish Lake and their land is too great of a sacrifice to make. Their cause must be heard in order to protect the land that rightfully belongs to them.